Hello, I'm Bruce Weber, Willem Quaker Dean of the Zicklin School of Business. It's my pleasure to welcome you to this episode of Zicklin Talks Business. Today's topic is law, religion, and business, the fallout from a recent Supreme Court decision. I have joining me from the Dean's office, Gwen Webb, Associate Dean for Executive Education, who will moderate the question and answer period. We're delighted to welcome to our panel today, Lucien Dhooge, the Sue and John Staton, Professor of Law at the Scheller College of Business at Georgia Institute of Technology. Joining Lucien is Debbie Kaminer, Professor, Department of Law at Zicklin, as well as Larry Zicklin, former chairman of Neuberger Berman, an alum of the college and the school's namesake. Larry also teaches in our undergraduate honors program. I look forward to gaining insights from today's discussion. And with that, I'll hand it over to you, Larry.
Thank you very much, Bruce. We're fortunate to have Debbie and Lucien with us this morning, who have expertise in this area that, frankly, I don't have. So let's begin immediately. The subject under discussion is religious accommodation, made a little bit either easier or more difficult by a recent Supreme Court decision, Graf versus Dhooge. So, Debbie, would you start in telling us what this decision was, Graf v. Dhooge?
Sure, I'm happy to. So this case was about a postal employee in a small rural USPS station. He was a Sabbatarian. He needed to have his Sunday off for religious reasons, and there simply were not enough people to cover for him. He had been subject to progressive discipline, and then he eventually resigned, and he sued under a federal law. And the federal law he sued under is called Title VII of the Civil Rights Act of 1964. And what this law says is that employers must reasonably accommodate employees unless the accommodation would cause an undue hardship. Now, the key point of this case is that undue hardship had been defined by the United States Supreme Court about 50 years ago to mean more than a de minimis or a minimal cost. So for 50 years, what the law was that employers had to accommodate religious employees unless it would lead to more than a minimal cost. And in this case, the Supreme Court ended up redefining this term undue hardship to mean substantial harm. And this is a pretty shocking decision because once the Supreme Court interprets a statute, the Supreme Court is not supposed to reinterpret the statute. If Congress disagrees with the interpretation of the statute, Congress can, and in the past many times Congress has, amended the statute. So the fact that the court actually reinterpreted the statute really violates basic separation of power principles. And I think it can really be seen as part of this general trend of the Roberts Court, balancing religious rights against other fundamental rights in a way that religious rights tend to almost always win. And this idea of, since at least World War II, the Roberts Court has been the most pro-religion court in this country. And I think that this can be seen within the context of this balance of religious rights to trump all other rights.
So we have also law that includes accommodation for people with disabilities. Does this law change how we accommodate people with disabilities? Or has that always been in effect the way the law is now interpreted for religious reasons?
Well, the law which mandates accommodation of disabilities, that's a different statute. That's the American with Disabilities Act. So this really does not have any type of direct impact or direct effect on that statute.
But is it also de minimis, or is it undue burden in that act?
Well, under the ADA, the Americans with Disabilities Act, the standard is significant difficulty or expense. So that standard seems to be even a little bit higher than what is required under Title VII with religious accommodation. But with religious accommodation, this new standard of substantial harm nobody even knows what that standard means. And when it comes to religious accommodation, there are certain unique harms that you simply don't have, unique concerns that you don't have with disability accommodation. So, for example, you have the issue of dignitary harms, where you have situations where a religious employee may want their speech, which is discriminatory against other employees, to be accommodated in the workplace.
So what do you see, and Lucien, just pop in at your discretion, what do you see as the ultimate implications of the Dhooge case?
Well, from my standpoint, the initial thing that struck me about this is the difficulty that HR managers and others in personnel are going to have with these accommodation requests. First of all, it's possible, and time will tell, of course, that there will be a flood of accommodation requests. You're going to have HR managers trying to figure out what do we mean by this substantial hardship. Because the court tells us in Dhooge that this is a case-by-case determination, which is wonderful when you look at this from a standpoint of justice. Is we'll develop this standard over time, but for somebody who's on the ground in human resources and has to interpret that today with requests with regard to a request from an employee for an accommodation, that's a whole nother issue. I also think that companies are going to have to do a better job of training in this area, and there's a temptation, I think, also to, in some ways, to rubber stamp these accommodation requests. Nobody wants a lawsuit. Nobody wants a complaint filed with the EEOC or harm to the company's reputation. And so, why not just give the accommodation rather than trying any pushback? Of course, that has also, and I know Debbie's talked about this before, has a potential impact on employee morale, coworkers as well.
How do you see the effect on employee morale? How will this affect employee morale, Lucien?
I'm sorry, yes. So when I think about employee morale, I think about some workers who won't be requesting accommodations, but will be perhaps forced to carry the burden for those workers who are accommodated. Also, there's a possibility, I mean, you could have workers who say, look, I don't have any particular religious affiliation, and yet I'm being required to carry a work burden for someone who's getting time off for some accommodation, whatever it might be, holiday, whatever it might be there. So I see this as a potential friction, some potential friction between co-workers, depending on the circumstances. And it's one thing to have a worker who says, hey, I need a day here or a day there. That's one thing. But if you've got shift workers, I think that creates another issue there as well, because someone's got to fill in for that shift worker. It's not just that someone takes the day and there's no need to have someone fill in. With shift work, someone's going to take that person's has to take that person's place on the line.
There are great many people. I'm sorry, Debbie. Go ahead.
Okay, look. I agree with Lucien. The two most common types of accommodation requests are what are known as time off cases and what are known as the religious expression cases. And we have a Supreme Court, which is the most pro-religion court in recent history, as well as the most pro-business court in recent history. So they came down with this decision, which essentially has a higher accommodation requirement, but there's also language that is going to make it possible for employers to simply shift this cost of accommodation onto coworkers. So, for example, if you think about the time off types of cases, an employee needs time off for religious reasons. Either the employer can bear the cost by paying overtime for someone or having a decrease in productivity, or employees can be told that they must work the religious employee's undesirable shift. My guess is that the burden is going to start being shifted to coworkers as opposed to the employer being the one who accepts the burden. The other type of case, the religious
Just stop there for 1 second, Debbie.
Sure.
On that subject, can you force a coworker to take a shift that he or she didn't sign up for when they took the job?
So that depends on issues such as seniority rights, contract rights. You're not going to be able to in every context, which is true and a valid point. In some contexts, you might be able to.
Okay, you were going to make a second point.
Oh, the second
before I
point are
interrupt
the
you.
religious expression cases. And these type of dignitary harms, I think, are extremely, extremely important, because within other contexts, such as with the case 303 Creative, there is this situation where you have religious rights or religious liberties being pitted against the rights of LGBTQ plus individuals, where a religious employee claims that they have a religious need to intentionally misgender a coworker, a religious need to put up statements in the workplace or send letters which are derogatory to people based on their sexual orientation or their gender identity. And under this higher standard, the substantial harm standard, I think you're going to end up having more of these types of cases. And in fact, the Seventh Circuit Court of Appeals just a month or two ago revived a case which involved a religious teacher in Indiana who claimed a religious right to intentionally misgender students in the school.
Can you define misgendering students?
Misgendering students is the situation where a student's biological sex doesn't conform with their gender identity.
And requests to be called something
Right.
other than what you would
Right,
expect
where
of the
they
gender
will
identity.
not call a student by their preferred pronoun or their preferred name.
Okay, does that mean that I could put a sign on my door in my office that is hurtful to people other than of my own religion?
Are you claiming you have a religious need to do that? Is a religious accommodation? Is that a religious?
I am, my religion promotes proselytizing. And therefore I put something on my door that accommodates proselytizing, because that's part of my religion.
So under the old standard, the de minimis standard, I would have said clearly the answer was no. So there was a case where a religious employee had sent letters, proselytizing letters to coworkers at home, including a letter to a coworker who was ill and told the coworker that the reason she was ill was because she had had an abortion. And that was found to be not protected religious speech. Under this new substantial harm standard, I have no idea. I think it's going to depend on the court. I think a court like the Fifth Circuit in Texas, the answer might be yes, but I don't know. These cases are just starting to come down now.
Case out of the Ninth Circuit from a few years back, Peterson versus Hewlett Packard. And in that particular case, the individual claimed that his religious beliefs were very much, he objected to members of the LGBTQ plus community, and he had posted scripture outside of his cubicle at the HP office in Boise that was extremely harmful to LGBTQ employees, such as quotes that such people might be put to death and the like. And the company had told him to remove that material, which he ultimately did. He was suspended. He came back. He put the material back outside of his cubicle and was subsequently terminated and brought an action against HP, claiming that they failed to accommodate his religion. This was religious discrimination. He was unsuccessful under the old standard. And the Ninth Circuit there looked at a couple of things I thought were interesting in terms of which may be helpful in interpreting the new standards here that Debbie has mentioned. One is that this could be harmful to HP's ability to retain employees, because no one wants to work in an environment where hateful comments are part and parcel or accepted by management. It might be difficult to recruit because again, no one wants to go work for a company where such behavior is tolerated. And so and also one other thing is that the court said that this employee has been accommodated enough. I mean, this employee was allowed to have anti-gay bumper stickers on his car, which he parked in the company parking lot. And it had also written a letter to the editor of a local newspaper complaining about HP's diversity campaign. And so without the company taking any action. So the court's view of this was, you've been accommodated, but inside the workplace and in a public area where people can see as they pass by this individual's cubicle is a step too far. Now, how that works in the new with the new standard remains to be seen, but I think there are some arguments that HP made that it was harmful to the company that might have some relevance for companies moving forward after the DeJoy case.
Do you think this decision will change recruiting? I'm thinking to myself, if I were an employer and I didn't want a plethora of these cases, I might be very careful who I recruited so I didn't have questions of religious accommodation.
Well, clearly, to refuse to hire somebody because of their religion,
But it would never be couched that way. In truth, you would never say that. You would just simply say you would reject that employee because of another reason. But the truthful reason would be you don't need a problem.
So you're asking, will employers engage in behavior as a result of this, which is both illegal and unethical? Some probably will.
I think you have to be really careful there, though. I agree with Debbie that, and it would have to, you obviously you're not going to put that out on the record, but we do know from the Abercrombie and Fitch, the A&F case a few years ago, back in 2005, if I'm not mistaken, there an individual was interviewed for a job at a store in Oklahoma and was wearing a hijab, and the company made the point of never asking why she was was dressed in this manner. She never volunteered. And then when she wasn't hired, she was told that she didn't fit the classic American look or classic preppy look that the company was trying to capture in its workforce. And Justice Scalia was pretty damning in his opinion when this got to the U.S. Supreme Court. He said, you didn't ask and she didn't tell, but it's pretty clear why you didn't hire her. Even though that topic never came up, it was the court was able to infer a discriminatory intent from that. So I would, if I was counseling a company, I'd say I don't think that's worth it. I mean, because eventually some claim is going to come up that someone was discriminated against in the hiring process based upon religious belief.
So just to stay on this dress matter, is any kind of dress to be permitted if it's couched in religious terms?
No, and the most common issue, well, there are a few issues. The time that courts are least likely to require religious garb is if there's any type of health or safety type of issue. So, for example, there are a whole bunch of cases involving guards who, have a religious need to wear a hijab or have a religious need to wear religious garb, which could be used, as a weapon. And in situations like that, courts have said that religious accommodation is not required. How this will occur during the new standard is unclear. On the other hand, you cannot refuse to allow someone to wear religious garb based on your bias against their religion. So you could not say that like a lawyer or an accountant couldn't wear a yarmulke or a hijab. It would have to be for some kind of security reason. One of the interesting types of cases is there are employers who claim that allowing employees to wear religious garb harms the brand of their business. And those cases in general, the employers have not been successful.
How about a religious meeting? We saw in the headlines a number of months ago about a football coach who had a prayer meeting on the 50-yard line after a game. Could we be seeing requests for prayer meetings at corporations in their offices?
So that case, that was a different type of case because that case was under the First Amendment of the United States Constitution. It wasn't a Title VII case. It is, though, part of the same general trend that I was mentioning a few minutes ago about the court being so pro-religion. I think we probably will. I think some employees probably will request that. You know, I started looking at cases that have come out post-Groff because there haven't been that many of them. And 2 weeks ago, there was a case that came out of the Fifth Circuit, which is the United States Court of Appeals for the Fifth Circuit, which is one of the most conservative federal appellate courts. And it involved a grooming policy at a prison that forbade men from having beards or long hair. And the reason they couldn't have beards is because they had to be able to wear like a gas mask type of thing if tear gas was being used. And the court in this case emphasized that significant religious accommodation is needed, that the court emphasized that an employer would have to show there is a heavy burden on them, that it is far greater than what the previous standard was. And the court also emphasized that impacts on coworkers in most cases is going to be off the table for consideration. So, for example, in this case, it didn't matter that because this religious employee couldn't wear a gas mask, it meant that his coworkers were going to have to do his share of dangerous work. So I think in parts of the country, this is going to be what's going to start happening.
Well, it seems to me that for the last 60 years or so, employers had considerable leeway in whether to make certain kinds of accommodations. Is that leeway now severely limited?
I don't know if I would call it severely limited, but I will say this, that a dismissive attitude and perhaps a bit of a mischaracterization, but a dismissive attitude towards accommodation requests in the past that's not going to be the case any longer. I mean, if a company really is suffering some type of hardship as a result of a request for accommodation, they're going to have to put their money where their mouth is. They're going to have to show it. Hey, this is the substantial hardship. Here are the distinct costs to us. They're going to have to do that, because just to, if you will, just to be dismissive and say, no, we don't need to accommodate you, no further discussion, isn't going to fly anymore. So companies, if they really do feel like they're being burdened, are going to have to demonstrate it. They're going to have to provide evidence. And so that's the one thing I see going forward here for companies. They're going to have to be able to demonstrate some type of burden. Although, as to Debbie's point earlier about this, we don't really know what that standard means yet. I think it's too new. So whatever that means, and of course, we're all in business school, so the thought is that it's always monetary. But I think there are other things out there that firms would consider.
Let me go back to basics now. I think I once read somewhere that there's something like 4,000 religions around the world. Does the Supreme Court define what a religion is and to what degree you have to accommodate based on the size of that religion, the number of members?
I don't think size necessarily matters. It's an interesting point there. I mean, when courts look at accommodation requests, they will say, well, this individual professes to be of this particular faith, but doesn't attend services or has views that are different than the mainstream thought within this person's faith tradition. Court doesn't care about that if their beliefs are different than their professed faith, or if they don't attend services or the like. And courts are going to be, I think, careful. They always have been careful about looking at sincerity of belief. Because once you get into trying to determine whether someone is sincere in their religious beliefs, there is a slippery slope there. I mean, how do you determine that? But I take your point there about this, Larry, that the concern is going to be if there are literally thousands religions out there, what do employers do? Because they're not going to be familiar with all of these, can't possibly be familiar with all of these faiths. And that creates, in some ways, I think it puts a burden on employees to educate their employers about this too. Here's why I need this accommodation. Here's my faith tradition. But should you be putting those burdens on employees to explain to their employers their beliefs, their faith traditions? But Debbie, what's your view on this as well? Do you see that with faiths that are perhaps not very well known or very small, what do employers do with that?
Yeah, I mean, it's a huge issue. Just to make clear and to emphasize something Lucien said, is that religion is defined extremely broadly, and religion does not only mean institutional religion. What the court has said is that religion means moral or ethical beliefs as to what is right or wrong that are sincerely held with the strength of traditional religious views. They concern ultimate ideas about life, purpose, and death. And the reason for this is that it is not the place of courts to go and determine what a religion requires. So religion is defined extremely broadly. Under the de minimis standard, it was easy for employers to say, even if someone's beliefs are religious, accommodating them would be more than a de minimis cost. So we don't need to worry about whether the beliefs were really religious or were not religious. Under this new standard, I agree with Lucien. I think the whole question of what is a religious belief is going to become a huge, huge issue.
There are millions and millions of vegans around the world. Could veganism be a religion?
Well, so this is interesting. There was one case that specifically said that with veganism, it all depends upon why you are a vegan. Is it part of a broader worldview, in which case it could be part of a religion, or are you doing it just for health reasons, that you think it's a healthier way to eat and to live your life?
What if I don't want to kill? If I don't want to kill animals?
Well, then that becomes the whole issue of, is not killing animals, is that just a very limited view, or is it part of your ultimate ideas about life, about purpose, about death? This actually,
Go ahead, I'm sorry.
This came up in the vaccine cases, because you know how a lot of employers had vaccine mandates during COVID, and there were employees who said they had a religious objection to being vaccinated. And there were courts that said simply having an objection to being vaccinated, that alone is not a broad-based belief system that counts as a religion.
But some of the vaccine cases too that are interesting is that inquiries into other issues here, and this also comes up, by the way, with respect to childhood vaccinations as well, and parental objections to having their children vaccinated. Have you or your children received vaccinations in the past?
Yeah.
Are you trying to be an a la carte, doing an a la carte objection? I've been vaccinated for this and for that, but I won't be vaccinated, for example, for against COVID. So again, those I think questions go to sincerity issues there, and so courts can, I think, at least in the childhood vaccination area, courts have looked at those types of issues as well, and so have state legislatures as well. Said, look, take one vaccination, you take them all, unless there's a health issue there. But this all goes to the issue of sincerity of belief as well. But I agree with Debbie that this is, given the breadth of how courts have defined religion, and in many of the cases that courts have said this is not a religious practice, we're talking about incarcerated individuals who are seeking special dispensation or accommodation from correctional authorities. And so courts there have been, I think, a little bit more restrictive on how they define what is truly a religious belief for purposes of incarceration. But for those individuals seeking accommodations who are not incarcerated, then I think it's the courts are going to have a much more difficult time saying this is not a religious belief. Because and to Debbie's point, Debbie, if I'm misstating you or misunderstanding you, please correct me here. But this whole issue of sincerity and the like, it's how you phrase it. I think here's my religious belief, and if you phrase it a certain way such that it sounds like it has medical physical basis, or it's your identity in life and it relates to ultimate issues, that can constitute a religion.
Yeah, I mean, like during the whole pandemic, the issue with requests from vaccine mandates, there was a cottage industry that developed where employees could get information online of how to phrase your request for an exemption from a vaccine mandate so it would come across as being religious.
Do business have the, I'm sorry.
I was just going to say, it reminds me of the going back now to the late 60s, early 70s, the Universalist Life Church, and applying for a minister card so that you could be exempt from serving, being drafted or serving overseas as well. And that attempt, the same sort of cottage industry kind of grew up there around selective service and Vietnam.
And if you're exempt by virtue of religious affiliation, can you be exempt or accommodated, I should say, for other reasons? I mean, when LGBTQ protected, will other people suddenly determine that they're going to be protected? Why is religion the only group that gets protected under this act? I know ADA.
Well, it's not that religion is the only group that gets protected under this act. This is Title VII prohibits discrimination based on a number of protected classes, which includes sex. And in a case from a few years ago, Bostock, the Supreme Court actually said that sex includes sexual orientation. So you can't discriminate against somebody based on their sexual orientation. But in Title VII, Section 701J of Title VII requires accommodation specifically of religion. So that is why it is only religion that you have this accommodation requirement for. And the reason why that was added into the statute in 1972 was that prior to that, what employers were saying was, we will not discriminate against somebody who's religious, but that doesn't mean we have to accommodate at all. So employers were essentially arguing we don't have to allow an Orthodox Jew to wear a yarmulke, even if they're just an attorney. We don't have to accommodate at all. So that's why this was added in. But, and this is where it gets kind of interesting, this act also prohibits what's known as a hostile work environment. So you can't, it would be illegal under Title VII for an employer to permit an environment which is harassing to members of protected classes. So you then end up having this conflict where you have to accommodate somebody's religious speech, but if their religious speech is intentionally misgendering somebody, or their religious speech is making harassing comments like the Peterson case Lucien discussed, that could cause a hostile work environment. So employers are stuck between a rock and a hard place.
The United States has a significant number of atheists. Are atheists who are in a hostile work environment protected?
Can you define atheism as a religion? I mean, it's because keep in mind that one of the things courts have talked about is that in order to qualify as a religion, you don't need to have a belief in a supreme being or a God. So the presence of a supreme being or God is irrelevant to this particular determination. So one might try to argue here that my beliefs are just as valid as someone who has what one might determine to be a traditional religious belief, be it in the Judeo-Christian tradition, whatever it might be. So I think you can, again, going back to Debbie's point about how you phrase it, one could make this argument that my views are just as valid and relate to the same sort of ultimate questions as as what one consider to be a traditional religious faith. It's just there's no belief in the supreme being there. So it's a very interesting question, especially given the large number of people who identify not perhaps as atheists, but as nones, have no religious affiliation whatsoever. And so, but so you don't want to just lump all those people together and say, well, they get no accommodation because they have no, they do not have beliefs within traditional religious bounds.
I think go ahead.
The other thing, which people, not necessarily atheists, but if people feel like the work environment is very disruptive, one of the arguments that had been made in the past many times is that accommodation is not required because it is an imposition on colleagues and too disruptive to the work environment. So, for example, there was one case where a religious employee claimed that she had a religious need to wear a button in the workplace, a graphic anti-abortion button of an aborted fetus, and it ended up being very disruptive. Her colleagues were very upset about it and ended up impacting productivity. So in cases like that, you can also have the argument, not that I'm opposed to your religious speech because I'm an atheist, but the way that you are proselytizing and expressing religion is an imposition and ends up impacting productivity in the workplace.
I guess this is opening up a hornet's nest. Question. Debbie, earlier on, you said that the Supreme Court, which is the most pro-religious and pro-business among Supreme Courts in history, this vote was a 9-0 unanimous vote. And the 3 liberal justices voted along with the 6 conservative justices. How do you explain that?
Yeah, I was shocked by this decision, and I was specifically shocked that it was a unanimous decision by Justice Scalia. I think it is very harmful that the 3 liberal justices went along with it, because unanimity alone makes it appear like it's a reasonable decision. The only reason I could guess that they did was to keep the court from even going further. Graf had asked for an even higher accommodation level than the accommodation level that the court ultimately determined was required. My only guess is that they did so to keep the court from going even further.
How much further could they have gone?
What Graf was asking for is what's known as a significant difficulty or expense standard. And that would have been a standard of totally rewriting this decision from 50 years ago that I had mentioned. What the court was able to do was to touch upon some language from the 50-year-old decision and say, because that decision said both de minimis and substantial harm, what we're going to do is focus on substantial harm instead. What Graf had wanted was essentially for the court to legislate from the bench and totally rewrite the statute.
So one other point here, and Debbie's done a fair amount of research in this particular area, and that relates to what I see as the court being somewhat disingenuous here, because they say we are not overruling the prior holding in Hardison back from 1977. We're not overruling that. The standard's always been this way, and they're trying to find some way to not overrule the case, but yet have a different standard. And Debbie, I'm curious as to your take on that, because when I read the opinion, times I've read the opinion, I keep shaking my head saying, but you are changing the standard, but this is just they're saying, no, this is an interpretation of the standard. We're not changing anything.
Yeah, I agree with Lucien. That is exactly what the court did. And I think the reason the court did that was it was a compromised position. During the oral arguments, it was very clear that the justices were looking for some type of a compromised position.
And they thought this was a compromise?
Yeah, I think so.
Are all businesses affected by this, or do you have to be of a certain size?
15 or more.
15 or more employees.
Yeah.
And what do you think the effect will be on unions whose workers are affected by this and have to engage in working hours they didn't intend to work when they took the jobs? Will you see more union grievances filed?
Potentially, I mean, again, this is one of those circumstances where the court oftentimes issues these rulings and then will leave it for later cases or for the business community or others to work out the details. And so how much the unions and collective bargaining agreements and the like were actually considered by the court, I can't say, but certainly it creates a tension there. So you've got workers who have contracts in place and have collective bargaining agreements in place, and now are being told that they might have to do something a little bit different to accommodate a coworker in the workplace, and that might run afoul of the agreement. So I think again, this is another one of those unknowns. We just don't know how this is going to come out and how companies are going to approach this with respect to workers, or HR departments and union representatives alike are going to approach this. But I agree. I mean, if I've got an agreement and I'm not required to work this particular shift, and yet I'm being told that I have to work this shift to accommodate another employee, there's a tension there. There's a conflict there that's going to have to be resolved.
And I do think that, so under the Hardison agreement, that case, the Hardison case, the case I keep mentioning, that from 50 years ago, the court made it very clear that employers do not have to violate collective bargaining agreements. My reading of Groff is that is still good law. So I don't think that collective bargaining agreements are going to be violated under this. I don't think. I could be wrong, but I don't think so.
I come out of the financial world. And periodically in the financial world, there's an all hands on deck call. There's a merger agreement. You need the bankers, you need the lawyers, you need the insurance people. You need to contact people around the world in your various offices. Are these folks exempt from that? The all hands on deck call?
Would it be a substantial harm to your business to exempt them? If it is, you don't have to exempt them.
And that also creates an interesting question too about who's essential to closing this transaction and who is not. I mean, do you have to have the big players there in order to close this? What about junior staff members who perhaps have done some piecemeal work on this particular transaction and the like? So it does kind of create, when you say all hands on deck, it really creates a situation where you have to determine who's essential and who's not, and that also, again, goes back to that also creates problems as well for folks making that determination as to who needs to be there and who doesn't. But yeah, a fair point. And again, we don't know how this all shakes out.
Seems to me businesses are going to be very busy determining whose rights are being violated and whose rights have to be protected. It's not what they're in business for. They sell widgets. It almost seems like busy work for them. Well, what happens if you join a business with the understanding, I'm talking about a Sabbatarian now, you join a business with the understanding that some Sunday work is required, and then you change your mind, or you become more closely aligned with the particular religion? Does what you did prior to joining make any difference at all, or the agreement you signed on to when you joined the firm?
Well, a few things. First of all, there's what you signed on to, and then there's what federal law requires. But another thing which is sort of interesting, and for any students who may be on this right now, is that the research shows that people in their 20s and 30s are much more likely to want to bring their whole selves into the workplace. They're much more likely to feel that they have a right to fully express themselves in the workplace, including expressing their religion. So to some extent, I think the norms of the workplace may be changing somewhat.
And how do you think?
Point that you raised there, Larry, is that what if I have been working for a firm for years and years, and then I have a religious experience, and all of a sudden my religious experience changes the way I view my work, and so it'd be tough for the employer to come back and say, well, but for years you were willing to work hours, all sorts of hours, and without accommodation. And now you've had this experience, and now your job description, you're asking us to change your description, change your hours, and the like. So that's kind of an interesting circumstance there as well. What do we do with people who have this religious experience or conversion? And now all of a sudden, or after years and years of not requesting accommodations or business as usual, are now requesting some sort of treatment from their employer. So that's kind of an interesting topic there as well. Just came to my mind as we're talking about this particular circumstance and all hands on deck sort of approach.
Let me just ask an opinion, and I know you can't really know the answer to this because it's in the future. In your opinion, what will be the greatest effect of this law? Where will we see the greatest controversies emerge from this law?
I think big picture, the broadest controversy is going to be coworkers being burdened by this. I think one of the biggest controversies is that the cost of accommodation is going to be shifted onto coworkers. And within that, I think one of the biggest issues is going to be like the case of 303 Creative, this conflict between LGBTQ plus rights and religious rights.
I would agree with that as well. And then short term, I also think that there's going to be tremendous uncertainty, and so you will have an increased number of claims from workers seeking accommodations, an uncertainty within management and personnel and HR offices, and the potential for a larger number of claims that actually get filed. And so that's the short term view there. And so we'll see how courts clarify these standards. And as Debbie pointed out earlier, these standards are going to be interpreted differently depending on where you are. The Fifth Circuit is going to take a different approach to these types of issues than obviously perhaps the Ninth Circuit or the Second Circuit might do. So the court has not washed its hands of this. It is not done because these cases will bubble up through the system over time. There will be conflicts amongst the circuits, and the court's going to have to clarify these standards. For right now, let the lower courts wrestle with this. Let businesses wrestle with this. But eventually, long term, the court's going to have to look at these issues again as they come through the judicial system.
Do you think this case just bubbled up from what's going on in the workplace? Or do you think the court itself prompted this case by giving hints as to what it wanted to hear?
Oh, the court totally made it clear they wanted to hear this case. There had been 3 cert petitions filed on this exact issue before, and the conservative justices in the court made it 100% clear that they wanted an appropriate case so they could reconsider the de minimis standard.
I'm very concerned about this. I'm very concerned about this going forward, that we have these cases that, for lack of a better term, I'll call setups, where the court kind of telegraphs what it would like, and you have cases filed that are setups. I would say that the case of the praying football coach was a setup. The 303 Creative case, where you have a website that hasn't even really hasn't received a request from a member of the LGBTQ community for a wedding site, wedding planning, or any of that. I get concerned that these cases are setups and are serving a specific agenda at the court from some members signaling what they would like to see. And
they signal in other opinions that they offer? Do they write the opinions in such a way that invite subsequent cases?
Yes, so it was in the denial of cert petition in an earlier request to reconsider the de minimis standard. There was a concurring opinion. It was either concurring opinion or dissent, I can't remember, where essentially it must have been a concurring opinion because it was a denial, which basically said this is not an appropriate case to hear the issue of the de minimis standard. For very specific procedural reasons, this is not an appropriate case. but we would like to take up this issue if an appropriate case is brought before us. So it was made 100% clear.
Got it. Gwen?
Hello, everyone. As usual, there are quite a few questions and not a lot of time, but let me start with them. Debbie, you said at the beginning that this current Supreme Court is both pro-religion and pro-business. To the extent that it requires employers to accommodate its employees' religious preferences, can we expect some of its interpretation in the future to favor business in terms of helping reduce the burden on them or shifting the burden, as you pointed out, to the employees?
So I don't think that this particular Supreme Court, I mean, I disagree with Lucien a little bit on this. I don't think it's going to reconsider the statute for a long time. I think, and I'm sorry if I wasn't clear with this, I think that it was in this particular case of Graf versus Dhooge that the court came down with the decision that it increased the religious accommodation burden, but wrote it in a way that is going to allow employers to shift the burden to their coworkers.
Okay, Lucien or Larry, any comment on that?
Yeah, I find it difficult to understand how a court can be pro-religion and pro-business. This decision was obviously not pro-business. This was pro-religion. I would argue this was anti-business.
No, it's Lucien, do you want to answer? I'm looking for the exact language I want to.
Yeah. So, and I think that the Roberts Court has some. It's difficult for the Roberts Court here because they are walking a fine line. In addition to being, I think, the most pro-religion court since at least the times of FDR, I also look at this and say this is the most pro-business court that we've had in some time as well. And so, how does the court walk that fine line between accommodating religion, but also not burdening businesses as well, given the perhaps the large number of requests that may be made per this new standard. So I agree entirely, Larry. I think this is and this court is has other issues here with respect to individual rights versus business as well. I mean, this is a very First Amendment court, a free speech court, but how do you balance that with business rights as well? So it's a tough one to walk. And Debbie,
And Larry, I think the way that this decision was both pro-religion and pro-business is that the court specifically said that in most cases, the burden on the coworker doesn't matter. So the decision was drafted in a way that there's a higher level of religious accommodation, but employers can shift this cost to coworkers.
I wonder what the coworkers would think of that. I'm sorry, Gwen.
I was going to, why don't we let that be the last word on this question? Another one that came up, is there any requirement for a religion to be recognized in any formal sense? I know you talked about this, but can anyone who starts his or her own religion demand accommodations? And how does this law actually deal with that?
So this case doesn't in any way address or change the definition of religion. There's no requirement at all that religion be part of an institutional religion. You know, in many cases, these requests for religious accommodation that come up through the courts, they are parts of institutional religions, but there's no requirement at all that that be the case. There's this broad definition that religion is this fundamental belief system that deals with ultimate questions. And, you know, if sort of the subtext of that question is, isn't that a very ambiguous definition? The answer is yes, it is.
Some other aspects of that as well. I mean, when we look at the definition of religion, and I agree with Debbie, we're talking about a moral or ethical systems that address ultimate life issues. Is it a comprehensive set of beliefs? Are there so-called accoutrements of religion? That is, there's ceremonies, there might be sort of rituals that are involved. Are there teachings that are consulted and the like? So an employer faced with this, and if they really want to deny an accommodation request and say, well, this is not a religion. There's no sincerity here. There's no belief structure. There's no view of the ultimate questions. There's no accoutrements of religion. I suppose they could do that, but there's no requirement that there be any sort of recognition. And in fact, adherence to certain beliefs can have beliefs that are different than the faith tradition that they profess to belong to. So it's, as Debbie had mentioned, it's very broad and it's very flexible.
But I just want to add that despite all of that, while that's the official definition, courts do tend to be a little bit more sympathetic to what you would think of as more traditional mainstream religious beliefs.
All right, Larry, we are short on time. I'd like you to have the last word on this. What do you feel are the key takeaways from this discussion? Will the discussion prove to be more helpful to people who have sincere religious convictions, or more confusing to business without really supporting their employees?
I have a belief that business has been basically accommodative toward religion. I think an act like this has consequences, and the consequences will not necessarily be good. I think you're going to have lots of appeals from employees to say they've been heavily burdened, and the results are substantial on them. I can just see somebody who says, I don't want to work overtime or work every fourth Sunday to accommodate other people. I want to go home to see my kids. I work a 5-day week and have a second job, and Sunday is a precious day to me. I think the Supreme Court has gone overboard in this, and I think employers are going to be very busy seeing requests for accommodation by others.
All right, I think we'll have to leave it there due to lack of time. I want to thank other people who posed questions that we didn't have time for. I would like to announce that our next webinar is November 14th. The title is When McKinsey Comes to Town, Are Some Clients Simply Too Toxic? It will feature Walt Bogdanich and Mike Forsythe, both reporters at the New York Times, and they are authors of the book published in the past year, When McKinsey Comes to Town, The Hidden Influence of the World's Most Powerful Consulting Firm. Thank you all for attending, and we'll see you on November 14th.
Thank you, Debbie. Thank you, Lucien.
Thank you, Debbie.
Everyone.
Thank you, Lucien. Thank you,
Great
Larry.
to be part of this.